So good morning, everyone, and thank you very much for joining us today. My name is Judith Riordan, and I'm joined this morning by my restructuring and insolvency partners, Maurice, Phelan and Flanagan. This is the second part of the webinar that we held on the 20th of May. On that day, we discussed issues which might arise in recommencing or increasing business activities after a period of lockdown, the risks of incurring new liabilities, either with trade creditors or banks, and the issues that may arise in dealing with existing creditors. So I suppose with the passage of almost 2 months and the increased business activity across the country, we're seeing from our interactions with clients that payment of creditors and uncertain cash flow remains a live issue for the majority of businesses. Therefore, this morning, we're going to consider ways in which problematic debt and other liabilities may be addressed through different types of restructuring. So restructuring is somewhat of an umbrella term for everything from renegotiating bank debt to the formal court-supervised process of examinership, along with everything else in between. So this morning, we're going to have a look at the benefits and some of the drawbacks of the various options, and also consider the circumstances in which the different processes might be utilised. As with our last session, we want to make this session as interactive as possible. So we're adopting a Q&A format, and you'll also notice the Q&A function on your screen. So please enter any questions that you have as we go along, and we'll answer as many of them at the end as we can. So to start off, Maurice, many businesses are obviously slowly reopening, having had minimal or perhaps no cash flow for several months. And many will have had significant landlords and supplier creditors who remain unpaid. What would you say is the best approach to deal with these debts?
Thanks, Judith, and good morning, everybody. And thanks again for joining our restructuring webinar series part 2. I think one of the key messages from our first webinar was the importance of having a plan in place, a plan that's grounded in a thorough analysis of the true position the company finds itself in. If that position is such that your business now has significant landlord and supplier creditors who remain unpaid, and there's no cash to pay them, but you're confident based on realistic cash flow projections that you'll be able to do so once trading gets back up and running again, then the best advice I think we can give is to engage with your creditors in as transparent a manner as possible. Honest and timely engagement with key creditors on an ongoing basis usually leads to the restructuring of agreements, if only for a short period, and an extension of credit terms to facilitate your business operating until trade gets back to normal levels. I go back to the ostrich analogy I used in our first webinar. Don't stick your head in the sand. Open, consistent, and timely communications with your creditors can't be overstated. I'll give you an example. Over the last 3 months, we've acted for tenants and landlords in relation to rent payment issues arising from the lockdown impact on the tenant's business. In all of the cases where agreements on temporary or short-term rent reductions or abatements were successfully negotiated, the tenants engaged openly with their landlord from the outset and were able to show their landlord a clear plan to recovery with the easing of restrictions. This, of course, instilled confidence in the landlords to know that although their tenant can't pay in the short term for reasons not of their doing and outside of their control, they should be able to resume normal payment terms in the near future with the resumption of economic activity. Failure to engage with creditors, be they landlords or supplier creditors, creates distrust and can lead to creditors thinking you simply won't pay rather than you can't pay. And once that trust is lost, it's very difficult to win it back. Of course, if you can't reach agreement with one or more of your key creditors, for whatever reason, it may then be necessary to consider more formal restructuring options, such as, for example, examinership and/or arrangements that can be made binding on your creditors.
I think the trust point is very important, and I'd also say probably don't overpromise. If you don't have 100 grand to pay an invoice on Friday, don't say it's going to be paid. That would be, in my experience, something that catches people out. Frank, a question that often arises is whether a business facing financial issues should talk to its bank and essential suppliers before attempting to do some form of restructuring. You might give us your thoughts on that.
Okay, unless a receiver has been appointed and the company needs to move very quickly to appoint an examiner, it should engage upfront with its bank and its key creditors, and there's a number of reasons for this. It might be possible to get to a consensual restructuring of the debt or a low-cost restructuring. If the company is going to accept credit from anybody while it's verging on insolvency, it needs to be open and transparent about the situation with the debtors. If the directors take on additional debt without actually being open and transparent, they're likely to face, they can potentially face personal liability and they can potentially face restriction proceedings. Once a company is verging on insolvency, the duties of the directors are actually owed to the creditors, not to the company. And finally, the attitude of the bank and the essential suppliers is going to be absolutely key if the company eventually does go for examinership. And if they believe the company hasn't been open and transparent with them, support from those creditors is much less likely.
Yeah, absolutely. I think creditor opposition is what everyone should aim to avoid, depending on the process that they wish to adopt. Okay, so Maurice, I suppose like everything in life, agreeing something consensually is always going to be better, but I suppose some creditors simply aren't going to be prepared to agree. You might briefly outline the options available in those circumstances.
Okay. Well, if open and timely engagement with creditors, as I mentioned earlier, doesn't bear fruit, and you're confident that your business is a viable undertaking, there are a number of options available to you. As we touched on, you can simply look to agree arrangements with some of your key creditors. Those kind of arrangements would not involve any formal court process and would not be binding on other creditors. There's also a risk that such arrangements could be deemed null and void as an unfair preference if your company was to go into liquidation within 6 months of the arrangement being made and no other creditors have been paid. You could agree a formal arrangement, which is provided for in the Companies Act 2014, Section 676, and that arrangement would be binding on all creditors if you have the support of 75% in number and value of the company's creditors. This type of arrangement does not need court approval, but it can be appealed by a creditor alleging unfair treatment, and that needs to be borne in mind when considering your options. The company can seek the appointment of an examiner. The examiner will formulate proposals for a scheme of arrangement which facilitates the survival of the company and the whole or part of its undertaking. The scheme must be approved by one class of creditor impacted by the scheme and must be approved by the court. Creditors can't enforce debts during the examinership period. And the final option that would be available is a formal scheme of arrangement. And that is provided for under Section 450 of the 2014 Act. And it can, subject to certain conditions being met, become binding on all of the company's creditors. This process is very flexible. It doesn't require that the company be or is likely to be insolvent, but it does require up to 2 applications to court, and that'll obviously increase cost. It does take time to put in place, and it doesn't offer protection from creditors during the process in the same way examinership does. So Judith, selecting the appropriate restructuring option will depend on a number of factors, including cost, and I can only recommend that if and before you take any particular course of action, that you get appropriate professional advice.
Okay, so maybe if we pick up on examinership in a little bit more detail, you might outline the process for us.
Okay, well, the principal rationale underlying the concept of examinership is to allow a company that's experienced financial difficulties a period of protection of up to a maximum of 100 days from creditor action. And during that period, a third party, the examiner, has an opportunity to examine the affairs of the company. And as I mentioned, if there's a reasonable prospect of the survival of the company and all are part of its undertaking as a going concern, the examiner will formulate proposals for a scheme of arrangement in order to facilitate such survival. Such a scheme often involves a new investor acquiring all or substantially all of the shareholding of the company, together with a write-down of the company's debt across a range of classes of creditors.
And maybe you might just touch on who can commence the process for the appointment of an examiner.
Okay, well, the petition can be brought by the company. It can be brought by the company's directors. It can be brought by its creditors, its shareholders, or any combination of those four parties. I mean, having regard to the information required to be presented to the court, both in the petition and the independent expert's report, which is a key proof in the petition application, in practice, creditors have been very slow to petition the court for an appointment of an examiner. More often than not, in our experience, Judith, the petition is presented by the company itself. And the petition must nominate an examiner, and it must be supported by evidence which is sufficient to demonstrate to the court that an examiner should be appointed. And the independent expert's report is a key piece in that.
So obviously we're talking about a court process when we're dealing with examinership. You might touch on the test that the court applies when considering whether to appoint an examiner to a company.
Okay, well, there's a legal test and then there's a discretion that rests with the court if that legal test is satisfied. So the principal legal test for the appointment of an examiner is whether or not there's a reasonable prospect of survival of the company and the whole or any part of its undertaking as a going concern. It's also necessary to demonstrate that the company is or is likely to be unable to pay its debts. Now, a company doesn't have to be insolvent at the time of presentation of the petition. The court can take account of a future event which is likely to have an adverse impact on the company's ability to pay its debts. However, an examiner can't be appointed to a company that's in liquidation, and also where a receiver stands appointed for a continuous period of 3 days or more, an examiner can't be appointed. And it's important to note that passing the legal test, as I say, for the appointment of an examiner doesn't guarantee that the examiner will be appointed. The court can exercise its discretion to dismiss a petition if, for example, there's a failure to disclose any material issue relevant to the application and the duty of utmost good faith on the part of the petitioner is not satisfied.
Absolutely. Maurice, you also mentioned that the scheme must be approved by one class of creditor and then by the court. You might just briefly outline this approval process and then what it looks like in practice.
Okay, in brief, the scheme must first be approved by one class of creditor. In practice, the unsecured creditor class will invariably vote in favour of the scheme proposals, as they usually provide for them receiving a higher dividend than they would get in a liquidation. Once the examiner has secured the approval of a scheme by one class of creditor, it's then up to the court to approve the scheme in order for it to become binding on all of the company's members and creditors affected by the proposals. The court has a discretion to confirm the proposals, modify or reject them. The court may not confirm the proposals if they are not fair and equitable, or if they are unfairly prejudicial to the interests of any interested party. And in practice, our experience is that the court is slow to find the proposals are unfair, or inequitable, or unfairly prejudicial in circumstances where the affected class will receive a higher dividend than in a liquidation or receivership.
Absolutely. Turning me frank, maybe one issue that often arises in the consideration of examinership, it's clearly very beneficial in dealing with legacy debt and dealing with problematic issues that the company may be experiencing, but fees are often a concern for clients. Would you say circuit court examinership is a good idea if that's a concern?
Circuit court examinership is available to small companies with turnover of less than about 8 million, balance sheet total of less than about 4.4 million, and a headcount of less than 50. It was introduced with the object of making examinership more cost effective. It's actually not having much of that result. When petitions are presented in the High Court by companies that would qualify for circuit court examinership, they're often actually referred to the circuit court anyway. The big problem is circuit court examinership doesn't actually save a wild pile, especially if they're heard outside Dublin. Most of the lawyers and accountants who act regularly in examinerships are based in Dublin. So if you've got, say, a simple motion to extend time that might take 1 to 2 hours if it was heard in Dublin, it wouldn't be unusual to see a posse of lawyers on a train to Castlebar who are going to bill for the entire day. So even if the company's lawyers are based in Castlebar, the company's costs may be lower. The overall cost for the examinership in that case is going to be much higher. And my suggestion there is, if you want to use circuit court examinership, consider changing your registered office to Dublin before you actually embark on the process.
Well, having been part of the posse on the train to Galway several times over summer in recent years, I think I'd agree with that. Maurice, just coming back to, I suppose, the optimal position of trying to agree discounts with creditors. If it is possible to agree discounts with the vast bulk of the creditors, would you still recommend pursuing an examinership?
In that scenario, Judith, no, I wouldn't recommend pursuing examinership. I think if you're confident that you'll get the support of 75% of your creditors for an arrangement that provides for a write-down of debt, the most appropriate option to avail of is a binding arrangement that I mentioned is provided under Section 676 of the 2014 Act. This really ultimately depends on how urgent your requirement to get court protection is. If you require immediate court protection, you may simply have no choice but to petition for an examinership. But if that urgency doesn't apply, I think in those circumstances, a binding arrangement would be more cost effective and more efficient. I think, in very simple terms, it's a lot less expensive than a formal examinership process. The issue, again, that you need to bear in mind in relation to the binding arrangement is that while if you do get the 75% required support of the creditors, and it is therefore binding on all of the company's creditors, the arrangement can be appealed by a creditor alleging unfair treatment. So you may not be able to avoid a day in court and the cost that goes with that. Separately, as I mentioned earlier, depending on the particular circumstances of any given case, consideration might also be given to a formal scheme of arrangement under Section 450 of the Act. The advantage of adopting this process is that there's no requirement that the company be or is likely to be insolvent. The disadvantage is that it requires up to 2 court applications, which carries a cost burden. It can take time to put in place, and it doesn't offer protection from creditors during the process in the same way as I mentioned examinership does. So when deciding on that piece, it comes down to the urgency of the need for court protection. If that urgency doesn't require immediate application for examinership protection, then I think the appropriate and most cost-efficient mechanism or option to avail of would be the 676 binding arrangement option.
Yeah, I think it's fair to say that the standout benefit of examinership is the insulation from creditor action.
Yeah.
Frank, just looking at examinership perhaps from a shareholder's perspective, I sometimes find that clients are surprised that there's a chance they could lose the business or lose control of the business, I should say, in an examinership process. You might outline why this is something to be very aware of from a shareholder's perspective.
Okay, thanks, Judith. The examiner's duty laid out in the Act is to formulate a scheme of arrangement that provides for the survival of the company and all or part of its undertaking. Usually the schemes that are put forward involve a new investment. It's possible in relation to businesses that have become insolvent purely as a result of COVID-19, that schemes might be put forward that simply involve rescheduling debt. But that would be a novel development, and we'll have to see how that develops. The courts have been really clear that the object of examinership is to protect the enterprise and the jobs it provides for the benefit of society. It's not there to protect shareholder interests. So if there's a new investment coming in, the shareholders may be significantly diluted or may be wiped out entirely based on that new investment. And there is nothing in the law designed to protect them. It's to protect employees, and it's to protect the business and therefore the wider economy. Absolutely,
but I suppose equally, whilst it's a risk that shareholders need to be very aware of, there's nothing to stop them absent, inappropriate behaviour becoming the new investor or the injecting fresh funds into the company. So I think there's a balance to be struck there. Again, just looking at businesses that may have contracts which are a financial burden, but which can't be terminated without penalty or risk of litigation. Frank, you might just outline what options could be available within a restructuring process to deal with those issues.
Sure. In examinership, owners' contracts can be repudiated. However, where a contract is repudiated, the losses arising from the termination are going to be calculated and allowed as an unsecured claim in the examinership. In reality, it's very likely there's only going to be a small dividend paid on those losses. So if we take a really simple example, let's say you have a building that you're renting at 1.2 million a year with a year left to run on the lease. And if we assume if the building was vacant today, it's going to let at an annual rent of 600,000, and it might take 3 months to relet. The court is, if in an examinership you repudiate that lease, the court is going to actually look at the losses. It's going to allow 300,000 in respect of the 3 months it's going to take to relet. It's going to allow 450,000 in respect of the reduction of rent in the remainder of the year, so that's 750,000. And if there was more than 1 year to run on that lease, the court is going to discount the subsequent years to arrive at a net present value, just based on the cost of money or cost of funds. And then a small dividend is going to get paid on that claim. So examinership in this instance is very binary, but it can always be used as a comparator in negotiation with creditors, particularly landlords. So you can put to the landlord, we can repudiate the lease or we can negotiate. And if we repudiate it, you're going to get 5%.
A good negotiation tool. Maurice, maybe just looking at the situation where a company may find itself in financial difficulty and the bank may be threatening to appoint a receiver. What needs to be done in order to preserve the option of examinership in those circumstances?
Okay, well, in those circumstances, it all comes down to timing, and the timing is very tight. So if you think examinership is the correct process to adopt in those circumstances, you need to act as quickly as possible, as the company can only be protected from the appointment of a receiver if it's in examinership and therefore under the protection of the court. So court protection of a failing company commences on the presentation of the petition for the appointment of an examiner and not from the date of the court order. That's an important point to note. If a receiver has already been appointed, a company has a period of 3 days only from the date of appointment of the receiver to present its examinership petition. So the time frame, as I mentioned, is very, very tight. And it's important to note here that the 3-day period runs over weekends and public holidays. So if a receiver is appointed, for example, on a Friday evening, a company considering examinership will have to marshal its lawyers over the weekend in order to prepare examinership papers and have them ready to be presented in court on Monday morning. And that's a lot of work to do in a very short time frame. If a company is successful in presenting its petition within the 3-day window period and the petition's granted, the court can make a number of orders regarding the receiver, such as the receiver stepping down, that the receiver from the date specified by the court act only in respect of certain assets specified by the court, that the receiver delivers all books, papers, other records which relate to the property or undertaking of the company that's in his or her possession or control, and that the receiver give the examiner full particulars of all his or her dealings with the property or undertaking of the company. In practice, what we find is that the order that's usually made is that the receiver simply steps down and ceases to act as receiver.
Yeah, so I think the key message from that is it's all about the timing and having enough time to get the application ready in order to make the application to court. Moving to, I suppose, perhaps slightly broader issues. Frank, obviously lots of businesses are in financial difficulty at the moment, be it solely because of the crisis or pre-existing financial issues. What would you say is something a business might be able to do to protect itself from counterparty credit risk?
Okay, sorry. The first thing they need to do is have open and frank discussions with all of the large customers and implement a sensible and proactive approach to credit management. In reality, you need to avoid overexposure to a small number of customers. And one of the things we've seen over the years is that if a customer to whom you provide credit dramatically increases its orders from you, it may actually indicate that they're unable to obtain credit from other suppliers who are demanding cash on delivery. So in some instances, it may be warranted to move to cash on delivery, or perhaps to reduce credit limits. And finally, you need to actually take a serious and hard look at your standard terms, particularly around retention of title. These are often quite weak.
Yeah, I'd agree with you around your point about retention of title clauses. I often find that they simply don't work when a company goes into the insolvency process. You touched there on cash on delivery. What about a debtor that may be in examinership? Is it possible to insist on cash on delivery?
Okay, first, you don't actually have to supply them at all. It's up to you. Secondly, you can absolutely, if you want to, require cash on delivery. And thirdly, as Maurice mentioned, there's restrictions on the payment of pre-petition debts. But if you're a key supplier to a customer, or to one of your customers that's in examinership, you may be able to get somewhere. There are two exceptions to the prohibition on the payment of pre-petition debts. The first is if the independent expert in his report recommended that payment and the court approves it. And the second is where the examiner actually applies to court to approve payment. And the court will approve payment if not making the payment would significantly reduce the prospect of the company surviving. Or, therefore, if supplies from you are critical to the survival of the business, you can push for payment of pre-petition debts as a condition of continuing to provide supplies to that company. But the examiner will need to actually apply to court to allow for this, unless it was in the independent expert's report. So you might want to consider allowing cash on delivery for a short period of time to allow that application to be brought. If you take a really simple example, if you provide an online booking system to a hotel that's in examinership and 50% of its business comes through your platform, then continued supply of your service is likely to be absolutely critical to the survival of that business, and you can probably push for full payment. On the other hand, if, say, you're a wine wholesaler supplying the same business, it's very likely they can obtain wine, even on a cash and delivery basis, from a number of other suppliers, so you won't have the leverage to actually get payment of your pre-petition debt, and it may seem somewhat arbitrary, but that's the way the law sits.
Absolutely, and I like your wine wholesaler example. It's very apt. We're just coming up to 11:30 now, so I'm just having a look here at some of the questions that have been coming in. Frank, I might come to you on the first one, which is somewhat related to a point that you have already touched on, but it's a very important question, I think. The question is it possible to compel a landlord to accept a rent reduction in an examinership?
No, it's absolutely, the court doesn't actually have a power to alter a contract, so it doesn't have a power to enforce a reduced rent. The only order the court can make is one that allows you to repudiate the contract, in this case a lease. So, as I mentioned earlier, any loss that might be suffered as a result of a court order repudiating the lease is going to constitute a claim against the company. But as a scheme of arrangement is going to cram down that debt, you might get paid perhaps 5 cents in the euro on that debt. So there's usually lots of scope to negotiate with landlords with the threat of a court application to repudiate a lease. The alternative, the stark choice for the landlord, is no rent or a reduced rent. This will work for you if, say, you've got a chain of 6 shops, and we've seen it work in those instances. It's not likely to work for you if you're in one business premises and you're absolutely dependent on that premises.
Absolutely. I think I mentioned earlier that it's a good negotiating tool for a landlord. I think in all my years, I've only had 2 applications actually heard and determined by a court. All of the others have been negotiated and agreed. Looking at a second question, Maurice, this is actually a very interesting one and very important. Is it possible to get rid of personal guarantees within the examinership process?
Well, the simple answer to that question is no, it's not possible to get rid of personal guarantees. While you can't, during the period of protection, enforce a guarantee given by third parties, the guarantor's liability remains, notwithstanding that the principal debt may be varied under the scheme. However, in order to pursue those rights, the creditor must take some time, but very specific, simple, but very specific procedural steps during the examinership process. If those steps aren't taken or are done incorrectly, then the benefit of the guarantee will fall away. And the prescribed process, Judith, requires the creditor to give the guarantor notice of the meeting of creditors to consider the scheme and vote in respect of the guaranteed debt. So for example, if a creditor obtains, say, 10 cents in the euro under the examiner's proposals, the creditor will be entitled to pursue the guarantor for the remaining 90% of the liability, so long as that creditor carried out, and to the letter carried out, the required notice procedures. It's really, really important to have a very clear visibility as to when you are given notice of the meeting of creditors, that you then in turn forward the notice to the guarantor. If you don't do that, and you don't do it in the way prescribed under the Act, then you could end up in a situation where your entitlement under the guarantee falls away.
Yeah, and I think you'd probably agree that a very practical issue is to ensure that there's a very clear and prompt chain of communication with the examiner's office. So, for example, if a post arrives into the bank and it's a big organization, that by the time it lands on the right desk, it could in fact be too late. So I think from the outset, that's something that's very important where there's an examinership ongoing.
Yeah, I think that's right. Yeah.
Yeah. Okay. Maurice, maybe I might come to you on this one as well. Little bit philosophical perhaps, but how do you think lenders will respond to requests for further restructuring of loans over the next few weeks and months?
Okay. Well, I think on balance, I'd say that lenders will absolutely be amenable to agreeing some form of restructuring, whether that's an extension of the term or revised repayment terms or something similar. I mean, leaving aside any regulatory obligations the bank may have in dealing with customers in financial difficulty, I think ultimately much is going to depend on, for example, the historic relationship between the lender and the customer, the transparency, to go back to what I was discussing earlier on, of any discussions that might take place as a result of the financial difficulties being faced arising from the pandemic. And perhaps most importantly, the borrower being able to clearly demonstrate how any restructured facility will be repaid. I mean, any request for a restructure of bank debt needs to be based on realistic projections. So if, I started in answering your first question, Judith, in emphasizing the importance of having a business plan in place that's based on realistic cash flow projections. And, you know, I can end it with answering that question you've just raised, with again emphasizing the importance when dealing with your lenders, who often can be the largest creditor of your business. It is really, really important to have open and transparent engagement with your lenders, and to have a plan based on realistic cash flow projections. So again, if you're looking to restructure a facility, you must be able to satisfy the bank that you'll be able to repay that restructured facility. And if you're able to do that, I've no doubt, based on our experience, that banks will be amenable to working with you.
Yeah, I think that's right. So I suppose in conclusion, I suppose there's very many options that might be available to restructure a business. And maybe to sum up two key takeaways, it might be to ensure there's clear visibility on each creditor's attitude to a potential restructure, particularly large and secured creditors, and to ensure that there is sufficient time to explore and implement a formal restructuring process if a more informal and consensual approach isn't feasible. We've covered an awful lot of issues this morning, so I would like to thank everyone for joining us this morning, and I hope you found it of assistance. Any questions that we didn't answer this morning will be collated, and email response will be circulated. And obviously, if anyone has any questions at any stage, feel free to call or email us at any stage. Thanks again for joining, and enjoy your day.
Thanks, everyone.